Hello.
Hi, Sushanth.
Hi, good morning. How are you?
Doing good. Can we first discuss last week's quiz?
Sure, definitely. Why not? Yeah. So, how did you find the quiz, by the way?
Yeah.
I mean, what are your feedbacks and what are the?
If one had paid attention in class, they will obviously pass.
Time
Okay.
was short, sir.
You can't
Okay.
Google. You can't Google it. As simple as that.
Time we
But
wanted more. Yeah.
okay. No, actually, the same thing. Last class also, when we had 1 hour only. But
Like
okay.
even if like we are reading each section in Google, say for
Mm-hmm.
example, still that takes time for each question.
Or phone just 1 second.
Time was less. In hurry, we selected the wrong options.
But how did you find the questions?
Questions were good, but time was less.
Okay. So we'll discuss the quiz first. That's what you're wanting to me to do, no? Shall we start? Waiting for anybody else. All the participants have joined. Hello.
Not
Yes,
all, but let's see. I have pinged in group. Let's see.
So let me know whether we can go ahead so that we'll start.
so let's start.
Okay, done. So we'll go to the quiz first, and then we'll probably go ahead and then go to the presentation next.
Sure, sir.
So in quiz totally we had about 20 questions if I'm not wrong. So basically all were MCQ type questions, and I just want to start with the first one. So the first one is a pretty simple one, as we discussed also in the class. See, a will with respect to a person's digital and electronic data is executed via email. Do you do any of
We are
the
not seeing screen.
provisions? Sorry, I have not casted it actually. 1 second, I just make it. Try to share my screen. Yeah, is my screen visible now?
No, not yet.
Now is it visible?
No, sir.
No, sir, still not it.
See now?
Yes, sir.
Is it visible now?
Yes, sir.
Everybody?
Yes, sir. Visible.
Yes, it is visible.
Okay. Now let's go to the first question. A will with respect to a person's digital and electronic data is executed via email. Do any of these provisions recognize the legal validity of the will? Obviously, it's no, because we discussed when we were discussing about IT Act, that IT Act provides legal recognition to all electronic documents except 4 or 5 rather: will, power of attorney, trust deed, negotiable instrument other than check, and any document relating to the sale of any immovable property. So if you look at the exceptions of the IT Act, so will is also accepted. It's not acceptable in the electronic format. So we specifically mentioned that it is executed via email. So it is an electronic will, which is executed not in the paper but on the email. So therefore, none of the above is the answer. So are we clear on it?
Yes, sir.
Done. A contract. Next question. A contract to sell a house has been executed via WhatsApp. Which of these provisions are applicable? First, we have to primarily understand that a house is an immovable property. So therefore, going back to the previous question, we have exceptions under the IT Act where any sale, any sale document with respect to any immovable property executed in the electronic format is excluded by the IT Act. So that means a contract to sell a house, which is an immovable property again, is not in the purview of IT Act. Why? Because I also gave you an example. Because you have to go through the stamp paper again, you have to go and register the document. So all these are the legal requisites. So therefore, that's the only reason why in the electronic format, any sale or any sale document which is executed via electronic format is not legally acceptable under IT Act. So this is the answer is none of the above. So are you clear on this as well? Are you clear? Any doubts? Okay, I'm moving to the third question. A chatbot communicates with the users of a website. So chatbot is we already I discussed about it. Chatbot is something which is electronic in nature. Basically, if you go to all these websites, right, specifically Samsung or any other company's website, they automatically have a pop-up that comes in. And likewise, if you're using Swiggy or Zomato, you already have a chatbot there. So it asks you predetermined questions, and based on the response that you choose, it actually directs you the further steps. So therefore, a chatbot communicates with the users of a website. Can such communication be attributable under IT Act? Identify the relevant provisions. We discussed also Section 11 of the IT Act. I told you attribution can be made in three ways. The attributor can be made to the originator if the originator himself sends a communication. Second, if there is somebody authorized by the originator to send any communication on his behalf or her behalf. Third, if there's an automatic system acting on behalf of the originator, sending a message. I already discussed with you, telling that once you drop down the messages in when you fill up forms or when you do any kinds of online surveys, automatically there is a predetermined response that comes up. Thank you for submitting your response. So that means it's an attribution directly given to the attributor, who's nothing but the originator, because the originator can program a computer system this way. So here, since the chatbot is also communicating on behalf of the website owner, so obviously such communication can be attributable. And attributable under which section? 11. Because 220 talks about electronic record, 10A talks about electronic contracts, 4 talks about authentication of electronic record. So obviously, the section that talks about attribution is only 11. So 11 is the right answer. So therefore, that is the second option. So are we clear on this question? Any doubts? Any clarifications? Are we clear? Participants, some response so that I go to the next question.
Yes, sir. We are good.
Yeah. Now the fourth question, A asks his secretary Y to send an email from A's account to B. B's secretary Z accesses the mail and reads it aloud to B. Identify the originator and receiver. So therefore, who is the receiver and who is the originator? We'll have to make out. So A asks his secretary. So if you look at the previous question that we discussed, so attribution. So you can attribute the originator in case somebody is acting on behalf of the originator. Here A is asking his secretary to send an email. So therefore he is authorizing his secretary to send an email on his behalf. So A will be the originator. Now B's secretary is again accessing it. So B again has got his secretary in who's actually authorized herein. So B is the receiver. So A is the originator, B is the receiver. So are we clear on this?
Yes, sir.
Okay, great. Now the fifth question. A sends an email at 11:59 a.m. to B. The email is received by B at 12:01 p.m. B accesses his email at 12:05 p.m. Identify the place at the time of dispatch and time of receipt under the IT Act. So the time of receipt and time of dispatch we have to identify. If you look at section 12 of the IT Act, we discussed about the time of dispatch and time of receipt. Sorry, 13, time and dispatch. So there I told you the moment I'm sending out an email, I also gave you this example. The moment I press the send button, it is going out of my control. So therefore, the time that is recorded there as sent, that will be the time of dispatch and the time it is reaching. So if you go back and understand, I told you if there's a designated computer resource, the moment it is entering the designated computer resource, the time is there. If I don't give you a designated resource, then the moment it is entering the computer system, the time is considered to be a time of receipt. Here, there's no mention with respect to the designated computer resource. So whether there's a computer resource designated or not, if there is no clarity with respect to that, then obviously once I access it, that will be the time of uh, once it is received, that will be the time of receipt. So 11:59 is the time of dispatch. 12:01 is the time of receipt. So since there is no designated computer resource here, it is the moment it is received, that will be the time of receipt and not accessed. Access will come into picture only in case I designate a particular computer resource and I do not send it to that, then the access point comes into picture. If I send it, then the moment I receive it, that is the time of receipt. So 11:59 is the time of dispatch, 12:01 is the time of receipt. So are you clear on this?
Yes, sir.
Now let's go to the sixth question. A enters into a contract with B for a professional engagement through LinkedIn. Yes. So professional engagement is clearly given. So therefore, there will be a professional services agreement or a professional engagement agreement executed. So that is executed through LinkedIn. So it's an electronic contract again. So therefore, it is given legal validity under Section 10A of the IT Act, because 10A of the IT Act provides legal recognition to electronic contracts. So this is a contract executed through LinkedIn for professional engagement. So therefore, it is coming under the purview of IT Act, and it is a legal contract, specifically because it's a professional engagement, and it is executed in the electronic format through LinkedIn. So obviously, it's an e-contract. So 10A is the right answer. So are you clear on this?
Yeah.
Yeah. So let's go to the next question. A government website is defaced with pornographic content. Identify the applicable sections in this scenario. So obviously, when there's a website, I already told you, web defacement means replacing the government website with some pornographic or some anti-national elements. I gave you even in the slides, if you see, I gave you a screenshot of a police department's website being hit. So therefore, since there is an offensive idea here, because it's both dishonesty and fraudulently are both the elements are present here, Section 66 will come into picture. So since there's an involvement of pornographic content, Section 67 will come into picture, and Section 43A because it's an unauthorized access. So unauthorized access coupled with intention. So 43 and 66 here. So answer is 43, 66, and 67. Are you clear on this?
Yeah.
To record a video footage of the residents of a room while serving the food in the room. Identify the relevant provisions. First, dishonest and fraudulent intention is there because he knows pretty well doing that is a fraudulent activity. Second, he has the awareness that this is not a good activity. I mean, it's not a legally what do you say acceptable act. So therefore, 66 will come into picture. And apart from this, 66E because there's a violation of personal privacy. Because when you use a pen cam, obviously just see, I dropped a hint over there while serving the food. So while how does anybody serve the food? They bend. So when they bend, obviously the pen cam is going to capture the footage of the private parts of an individual, which means that there's a violation of individual privacy. So therefore, Section 66E will come into picture here. So the answer is 66 and 66E. So are you clear with this question?
Yeah.
So let's go to the next one. A changes the attributes of a file such that the file becomes read only and the editing in the file is disabled. It is enabled. Identify the relevant provisions. So therefore, first of all, he has done that with a fraudulent and a dishonest intention. Otherwise, why should he change the attributes such that only read only? So therefore, 66 will come into picture. If you go back and see 43, diminishing the value and utility of an electronic record without the permission of the owner. So therefore, there's no permission of from the owner of the computer or the computer system. So therefore, it's also affecting the document, the value and utility of the document, such that the attributes, once they're modified, it becomes read only. So it is affecting the document. So therefore, 43 I is also going to be made applicable here.
A quick
So
question.
that's,
Sir.
please go ahead.
So since the term is used very generic, what if
Yes.
it is my file and I wanted to make it as a read only? I have all authority to do that, right?
Yeah, but we see we have not specific. There's no specification with respect to whether it's my document or not. So obviously, when you
Exactly.
read it.
Hello.
Yeah, please go ahead.
Yeah, that's what exactly. So it is not specified, but how can we use that particular section if it is not specific?
See, you when it if it is my own document, then it will clearly be written that I am modifying my document or my file. So when since we do not have the fact mentioned that it is my document, so therefore it's obviously meaning that it's another document.
Okay.
So if I'm changing my own document, I will say at least my document or my system. I have not specified anything in the question, which
Hmm.
means it can be any other document.
All right. Okay.
Done. So let's go to the next question. A secures access to the wireless internet connection belonging to B, that means Wi-Fi of B, on his mobile phone without the permission and knowledge. Identify the relevant provision. So the point is without knowledge, whether there is a dishonest and fraudulent intention thereof, we are not aware of. Only dishonest can be there, but fraudulent intention is not specified. So 66 will not come into picture clearly. And A, because I'm securing access or to the respective Wi-Fi. H, because the Wi-Fi is again going to be paid. It's a charges availed by one person on the account of other. So therefore, 43 H will also be made applicable to this case. So are you clear on this?
Yes.
Done. Let's go to the 11th question. Which of these is a computer under the IT Act 2000? An electric rice cooker. So electric rice cooker, remote controlled fan, HDMI based TV, and electric doorbell. Remote control fan cannot do anything because it cannot do anything without our knowledge. First thing, we need to control it. HDMI based TV, whether we do not have an idea whether that TV has got memory or things like that. It's just HDMI. HDMI today is available for any TV. Electric doorbell also we do not have a complete clarity because no storage can be made. But on the electric rice cooker front, electric rice cooker will be the correct answer because it's a computer. Why is it a computer? Because it once you program it and figure it and give instructions, say that you put the rice, you figure it out, and you have an option to say cook. Once you cook, it is following the instructions put there, and then it is giving you the required result. So based on all these, the close relation that has that one of them have to the definition of computer is only an electric rice cooker. So that's the answer basically. Are we clear on this?
A bit confusing is what I feel.
Okay.
Because
Okay.
if you take a case like a TV with
Okay.
HDMI port, we don't have old TVs with HDMI port. Only the smart
Mhm.
TVs we have it with
But
HDMI
that's
port.
why clearly
So,
it is not mentioned as smart TV there.
But
no,
also
but
an assumption, right? So as
Please.
Vijay
exactly.
So
right
yeah,
mentioned,
see, assumption I totally understand, but see, what I would want you to look at is what is the term signifying over there. When I just say TV, does it mean see when I say it's a TV, can it relate to smart TV?
with
What's the
HDMI, yes,
normal?
I would
But
go with.
No, no,
HDMI is only
HDMI is
available in
there.
smart TV.
No, no, no. It is there even in the non-smart televisions. Sony has got that. I personally have one which does not have, it's not a smart TV, but it's still the old manufacturer, of Sony, sorry, where we do not have smart connectivity, but still there's there. So that's why please look at the question. See, had it been a smart TV, we would have mentioned that as smart TV. See, a lot of difference is there between the smart TV and the non-smart TV. So the fact is, the questions definitely would be confusing you. But what you'll have to rely primarily is look at the terms and terminologies being used. HDMI cable cannot be considered can be considered for any television. But what about the smart TV? Is there a mention about smart TV or an internet TV here? No, that means it's a normal ordinary TV that you will have to look at.
Yeah, it might be a bit augmentative, but don't you think that even electric doorbell also would come under electric because
There's no control of the same, no, basically. How is it giving an instruction there?
okay,
But again, this is our assumption, isn't it?
yeah, because electric is something like again a huge scope, so it can be even what is the automated one, a doorbell nowadays with have like so much of features and all those things. Again, that's
See,
electric.
automated, we clearly mention about automated. No, see, any electric, see, any doorbell that you have today, it's also connected to a wire. See, you forget, automated for a minute. How does a bell work? You tell me.
Electric.
So, right. So if I have a bell which is fitted to my door now, which say if I just hit the bell now, can I say that it's a computer?
The same thing I can say it with the rice cooker.
Rice cooker
No,
as well.
rice cooker at least gives you. It has the power to what do you say and understand and follow the instructions. No, you can put it just for heating. You can put it for even cooking rice. No, both are different
So this can be
functionalities
our
altogether.
assumption as well, isn't it, Sushanth? Because there can be a rice cooker only with electrical signals for heating purpose,
We
like
are not calling it a
kettle.
smart rice cooker.
Exactly.
No,
Otherwise, it
there
should
is no
be
question of
electronic
smart here.
rice
No,
cooker
no,
or
there's
smart
no
rice
smart.
cooker.
No, there
Yeah,
is no
or
there's no mention
yeah.
about
Sorry.
smart at all here. See, normally what I mean, just look at the normal rice cooker that is there, right? Forget even the smart which has got the capacity of connecting to the internet. Forget even that. My only question to you is your ordinary electric rice cooker. What does it perform? What are the functionalities it has?
Okay, so it is simple. There is a on button when you switch on.
Uh, uh,
It
Uh,
heats
gets
and it
heated
boils.
and it cooks. And the
uh-huh,
same with the electric button as doorbell.
uh-huh.
When you click the
Yes,
button, it says sound ting tong. So
okay,
both functionality
okay.
is the same, right?
No, no, no,
Exactly.
no,
And
no, no, no,
same with the
no,
electric
no, no,
kettle as well, where we
no, no,
heat
no.
water.
No, no, no.
So the
Please,
word
please.
here again, sorry, Sushant, maybe our assumption or not even an assumption, if you go by the words electric and
Mhm.
electronic, there is a difference. I hope you
Yes,
understand. If it is a
yes.
electronic, it comes under computer. If it is only
Okay,
electric, it is not a computer, as you
okay.
mentioned.
So,
So if you
no,
go
no.
by the words
Okay,
captured in the
okay,
document is what
okay,
the thought here.
okay,
Maybe I can be wrong, but I'm
okay,
trying to understand myself.
okay, okay. Let me clarify that very clear. I mean, very clearly to you. Okay. So, see, there is electric rice cooker. See, just Google what's an electric rice cooker. What features that is has. It has not just one feature of heating, but there both options are available with you. You can choose what you want over there on the electric rice cooker. See, just Google it. You will find that electric rice cooker has got multiple options. What are the normal options that it is provided? One is for cooking rice, one is for heating. That means you have to choose the mode that you have. That's a common thing of an electric rice cooker. But for a doorbell, other than just pressing the doorbell, there's no other thing activity happening here. But here you got the choice to put it either in either for cooking or for heating. It's a common principle. It's not even there anywhere else. See, you just
Exactly,
open
Sushant.
the normal thing.
Sorry for interruption. There are
Please go ahead.
doorbells with which is electrical, but it plays the
Mm-hmm.
music as well. So it has
Okay.
a memory in it. So it can also
Okay.
be smart.
See, only one. This one is there. No, it does not. See, you understand what I'm trying to see. I mean here, it is understanding the instructions given by you in a doorbell. What are the instructions given by you? Can you change the tunes for one person?
Yep, we can.
See, but the electric doorbell versus electric rice cooker. See, just understand the functionality over there. That's only request.
Okay.
Because see, the normal doorbell today also is an electric doorbell. Because how does a bell work? Bell works only when there is a connection of the wire which is there, basically, right? Otherwise, how does a bell work? So just look at the, examine that from that perspective. That's the only thing that I would want you to look at.
Hello guys, can you able to hear me?
Yeah.
Yeah, please go ahead.
Sushanth, the thing is, we are okay with explanation about the remaining three options.
Okay.
It's just that it's hard to believe that rice cooker comes under IT Act.
Okay.
That is the only problem with us.
Okay. See, when we are just going by the interpretation here, basically.
Most of the people, when answering this question, they would have thought only one thing: can we hack the rice cooker? No. So rice cooker is not the answer.
Well,
Okay.
to be honest, I got the answer right, but it's just an understanding.
Yeah, it's just unsatisfactory.
See, satisfaction and unsatisfaction. See, legal. There, I mean, even if you are not satisfied with the judgment given by the court, you have got nothing. No other option. No? You can go for an appeal to Supreme Court max. But what if you are not happy with the decision of Supreme Court? You can't go beyond that.
I mean,
So
the
that is
facts
where I said.
we can take it right. So,
Sorry.
I mean, it's all about the law, right? We just find the loophole
Correct.
and try to defend ourselves, kind of thing. I mean, we are just trying to be very more stimulative. So, other than that, we don't have any arguments on that.
No
Yeah,
issue, no issue.
yeah.
I'll welcome those things, no problem at all. Then probably we should have a good see. If that be the interpretation understanding, then I would love to have one small debate on whether we can have one particular debate and where for and against could be argued, and then we can have a good discussion. So thereby interesting deliberations can come out of the discussion, basically. I would love to hear your interpretation answers because since you say stimulative, yeah, I think that I would love to hear your stimulative answers as well. Okay, going forward to the next question. A receives, okay. Before I go to 12th, let us go to 13th because 13th has similar thing what we have with respect to which of these is not a computer under the IT Act. So smart bottled water is not a computer because smart water bottle, smart remote controlled AC, smart refrigerator, smart TV. There's a brand by the name Smart. I do not know whether you are aware of it or not.
No.
Yes.
No, we are not.
See, do you have Google? Please open Google and see smart water. That is the only reason for giving me. Since anyway you have access to Google, so I thought let me also give you one such question where you'll look at it. Did you get it? Anybody? Did you Google it? Smart water.
There is a
It's a brand
brand.
of. It's a brand of Coca-Cola.
That may be true, but
Okay.
most
Yeah,
people,
yeah.
when we are, yeah,
It's
Richie, one moment.
Mhm.
So when usually when we are talking about smart IoT items,
Uh-huh.
so when you say smart bottled water, we usually think our mind will go back to that it's an IoT item. So
Correct.
smart refrigerator, yeah, it's controlled
Mhm.
by mobile these days. Smart TV, yeah, it can be
Yes.
controlled. Smart water bottle. If I particularly have seen that there are few water bottles
See,
which
water
can
bottle
be.
is no. Water bottle is different from bottled water. No, please understand it. What do you call a mineral water? Bottled water.
Oh
See,
my God, then it's wrong from the English perspective, not
Sorry?
the law perspective, but English perspective.
Smart bottled water. So it's a confusion that is intended to create confusion. See, just like I was sure that because you have access to Google. See, had you not had access to Google, then I would have
Yeah, still
understood this
there is
question.
the name is wrong. It is smart water. It's not smart bottled water. The brand name itself is smart water.
No.
So it
Normally,
should
what we
be
call
smart
what
water.
what do you
Bottled
normally
water.
call water? Mineral water.
No, I'm fine with the logic what you're saying, but the only thing is that smart, it's a partial name of it. It's a smart
Correct.
water.
Okay.
As per the
Okay.
Google, I mean, I'm not going beyond that. So what
Okay.
it says is smart water. The name of the water bottle itself is a smart water. So which means then if that's the case, it should be smart water, bottled water.
Sorry.
So
Smart
water, bottled
Okay.
water. That should be the
Okay.
name because the name itself is a smart water.
Okay, that's a brand name called Smart, and then probably see bottled water is another synonym for mineral water, which is sealed, basically.
Wait 1 second.
Yeah. Just see what's bottled water.
Yeah, that we agree. Totally agree with you.
No, sir,
But
the company name is Smart Water. You mentioned the company name is Smart, right? So
yeah, so
the
I've been
company name is Smart Water. So that's a half name provided.
Sorry. See, you Google it, you would have got the answer.
yeah,
So
yeah.
that's
Yeah,
why
that
I'm trying
particular
to say.
company is Smart Water. It's not only Smart.
I pinged you the
See,
snapshot of
bottled
it.
water. See, bottled water means mineral water. See, the intention. I'll tell you very clearly. See, intention is bottled water. Normally, we call it for mineral water. So, smart mineral water is something we try to put in over there. Okay. In the meantime, let's finish the others because we are on the time now. Let's go to the 12th question. A receives a message which appears to be from the bank along with a link asking him to enter his personal details. Identify the applicable provisions. So this is what is it called? This is phishing because when you create something which appears from the bank and you try to ask details, it's clearly I can almost say it's one form of phishing through SMS. So therefore, there's a fraudulent and dishonest intention here because it says appeared. So since that is there, 66 will come into picture. Identity theft again, taking the identity from the bank. So therefore, 66C, cheating by impersonation because I'm making the message appear as if it is from the bank. So therefore, 66D. So 66, 66C, 66D will be the right answer. Are we clear on this?
Yes, sir.
Done. Okay, let's go to the 14th one. Which of these is not an electronic record under the IT Act? So basically, printout of an email. It's not an electronic record. Why? Because electronic record means something which is created using an electronic equipment. Which is PDF is there, SMS is there, WhatsApp is there. Physical printout is entirely different, though it's of an email. So therefore, that's not an electronic record under the IT Act. It's a printout again. It's a secondary evidence, basically. If you go back to the section. So are we clear?
Sir, you're not audible.
Am I audible now?
Yes, sir.
Yeah. So 14th, what I was trying to tell you is which of these is not an electronic record under the IT Act. PDF is obviously created only using a computer. It's an electronic record. SMS using again a mobile. Again, it's an electronic record. WhatsApp conversation, obviously, because it's only generated through WhatsApp, which is be there either on a phone or on a device, including a computer. You can have even the web version of WhatsApp. But printout of an email is something which is physical in nature. So it's not an electronic record under the IT Act. So therefore, 14C is the right answer. Are we clear on this? Participants, are you clear on this?
Yes.
Yeah, this is simple. Yeah.
Yeah. So let's go to the next one. Which of these is not covered under the IT Act? Stamp paper related offences, obviously. That's also very pretty simple because we do not have stamp paper yet. So therefore, no stamp paper related offences are not covered under the IT Act currently. That's why I said stamp paper. If had it been electronic stamp paper, then it's an entirely different matter altogether. So are you clear on this as well?
Yes, sir.
Okay. Which of these is not an offense under the IT Act? Phishing, obviously, because phishing is you have an intention to create something which is wrong. Actus reus again is there for both these elements. So you have both the elements required for a crime. So phishing cannot be is an offense. And I told you, offense means it is criminal in nature, and contravention means it is civil in nature. So obviously, cheating by impersonation again, it's again a criminal act, so covered under 66C of the IT Act or D of the IT Act. Salami attack we also discussed. So I should have both the intention as well as the idea of doing something wrong. Both these are present even in salami attack. So the only answer left is merely accessing. So that is where I said section 43 will come into picture. 43 is only relating to civil matters, which are specifically relating to what do you say matters which are
Sir, so hacking to a computer is not under the IT Act.
hacking is an entirely different matter. Hacking is covered here, covered under both the 66 if you have an intention, without intention 43.
I mean, without intention, why would someone hack?
No, why not? I don't do any damage. See, I just do it for the purpose of just doing some getting some information. For example, I told you that girl's case, no, where a chartered accountant student logged into the income tax accounts of these celebrities just to understand how much of income tax these guys are paying. So no intention of causing any damage there, but whatever has been done is done basically. So therefore, a penalty and
It's PI information. You're viewing the PI information. You're not supposed to view other person's account itself, right? It's a personal information.
yes. See,
So
the act itself is wrong. It can be considered a crime. It can be considered as a contravention, both.
okay.
But all that matters is if you have a dishonest and fraudulent intention, again, I'll go with 66 basically. So if I just do it for the purpose of accessing it, let's say that I just plug in a pen drive. So there's no intention to do anything there. But pen drive is again going to access the computer because for the purpose of reading it. So therefore, that can be a simple violation. Simple violation versus a serious violation. So that is where I also gave you the example of a vehicle. Let's say you're bypassing a signal. That's a traffic violation basically. But you go and hit somebody on the road. That's a serious violation. That is an offense basically. That's why you will be charged with rash and negligent driving, which is a criminal offense. But here it's a civil offense. Therefore, you would be only asked to pay fine, 100 rupees or 150, whatever be it. So therefore, that's the distinction you have to keep in mind. So that is why merely accessing and securing access is not an offense. Merely, that's why. Again, if you have dishonest and fraudulent intention, etc., you can again make it a criminal offense as well. Basically, are we clear on that? Participants, are we clear on that?
Mostly, But
What is your doubt? Please go ahead.
so yeah, so I was thinking you haven't mentioned what kind of
No, I said
cheating by
mere access. Mere access or securing access, go to 43A. 43 small a. It says merely accessing or securing access to a computer. It's not an
it's
offense.
still okay. It's still come on
See, it
Right
is an,
Act, right?
yes, it is. It's a contravention. It's a contravention. See, civil and criminal both are entirely different. If you recall the discussion we had, I told you for civil matters you can only get damages. That is by way of compensation. Criminal, you can
I
send someone
understand.
to jail. So
So
the question
okay, I
relates to
understand.
whether it's
But
an offense under ITI. See, offense is only serious violations which are under 65 to 74 of the ITI. Nothing else more than that.
okay,
If I were to
let's
say,
put aside the act numbers as for now. So my question is in here is
uh,
um, okay. So when they say mere accessing or security, accessing any computer. So if I go
yes,
to any other like any organization, either government or private,
mm-hmm,
I do not have any intention of doing anything wrong, but I just
mm-hmm,
go ahead. I do not have permission. I just
mm-hmm,
went ahead and access a computer. I saw that
okay,
someone was using computer and left without locking it. I was just
okay,
going and going through the files in the system.
okay, okay.
Uh,
See, going through
as
the
per
files is an entirely no. Going through a files is entirely a different matter altogether. You can't club it in this example. See, accessing it is entirely different. If you're going through the files, again, download, copy, extract data.
no, I'm not downloading. I'm not
Oh,
copying any. I
so
am not doing anything. I'm just looking what are the files that are
See, looking,
available
see,
on the system.
it is looking like a very extension to you, but legally speaking, that's a different act altogether. We'll discuss about the files and PI and all that in today's session. Don't get
so
into
what
that
do
yet.
we call it as securing means?
Sorry, you
Say,
access it. You access the
yeah.
respective computer.
So
You switch it on.
yeah,
You
browsing a
switch it on.
document also is called as accessing, right? I mean, I'm talking from
Yes.
a layman term.
No. I'm talking about accessing a computer. See, accessing a computer, accessing a document entirely is different. No.
Sir, I think accessing a computer, as per my knowledge, I
Hmm?
have seen what is happening in private organizations. If you just access to a computer, which you are not supposed to do, it doesn't matter whether you went through the files or not. It will still come under you have access to the files, even though you
Offense.
haven't seen nothing.
Unauthorized access.
See, first
Yes,
let us
unauthorized
understand.
access. Sir,
Okay, first let us. Okay, please go ahead. Go ahead.
understand the explanation, but this is how the real life experience will be. So if I went ahead and access some other system in my office, which I'm not supposed to do, it
Mm-hmm.
doesn't matter whether I have gone through the files or not, but it still come under offense as per the company.
No. See, our company is not to determine an offense or not. No company is above the law. See, intention has to be looked into. See, that is where I said you should think in the hands of a lawyer, not as a company. 90% of the companies make a mistake here. See, there's a lot of difference between an offense and a contravention. Contravention is very civil in nature. You can't send somebody to jail because I just accessed your computer. If I had the intention, see, two elements there again. If I have the intention to do something wrong, I have actually done something wrong, then absolutely I can constitute a crime. And if I can prove that there's a dishonest and fraudulent intention in me accessing the computer, then it's an offense altogether. But merely doing that, it's not an offense. It's only a contravention. So don't
So
get
okay,
carried away by that, because
okay.
90% of the companies do not understand the distinction there. Because should you want to understand that, there should be a lawyer behind it. Otherwise, you can't understand the difference there. So you should have a
I
legal.
understand that you are speaking about law perspective. So
Yeah,
I
we
was
should see
merely
offense. Offense. See, the discussion here is not technical. The discussion is purely about legal. Offense is not termed by any offense or whatever definition you're calling it, right? Offense or contravention. These are legal terms. These are not generic terms. So wherefore, if when you're looking at it from a when you're understanding about a term, you should understand who coined the term, what is the purpose of coining the term before getting into that. So when if your policy says that merely accessing it, then it should be a protected system under the IT Act. Otherwise, you can't consider that as an offense per se. Just merely accessing it. Later on, it's you can try to interpret it in a different way altogether. But right now, it's not an offense because merely accessing and securing access is not an offense. It's a contravention. Still, it's covered under IT Act. Still, you have 43. I'm not saying it is not covered under the IT Act. It's still covered, but it's covered under a civil section. Provided I'm able to establish dishonesty and fraudulent intention. If I'm able to establish that, and I can also bring in a criminal element here, there basically.
Okay, sir. What about the option C, cheating by
Which one?
impersonation?
See,
But
there is no
it hasn't.
impersonation here. There's no cheating by impersonation happening here, right? Why is cheating by impersonation not happening here? It's an offense here because when I'm trying to cheat by impersonation, I have both the idea. I have the idea that I'm not the original person. I'm impersonating as somebody. So there is knowledge involved there, and I know that the act whatever I'm doing is not right. So two elements required for a crime, which is mens rea, the intention, the actus reus, which is the idea of doing wrong. Both these are present. That's why it's called a criminal offense.
Yes, I understand, but it doesn't specify what kind of impersonation here. Because if
No.
a physical person comes to you and
You are
says
not
that
getting the
he's from,
logic. No. You are not getting the logic right. The logic is what do you mean by cheating by impersonation? The term itself legally says that if I call this as cheating by impersonation, that means both these are elements are present. That means it's an offense. Very
yes, sir,
clearly.
cheating by impersonation is an offense. But
Correct.
what if the impersonation is an physical?
See, what do you mean by impersonation? Tell me.
So, like
If I look into your
saying
system, that is
that I
impersonation.
am a person who's I'm not. So, if
Okay.
I am physically went to some person and say that I am coming from this bank and give me your details, so will it come still and comes under IT Act? I haven't
No, it
gone through
won't.
any
It won't.
electronic media.
It
I have
won't.
gone to them
It won't.
by person.
It won't come into. It won't. It'll come under 415, 416 of IPC.
Okay. So how can we say that cannot be the answer, because that is what I have
No, you are not
went through, because
understanding the point here. You are not understanding the point here. IPC means it's an Indian Penal Code. It's an offense. It is a penal statute. That means whatever are offenses only those penalties are mentioned under the IPC. Otherwise, IPC does not cover civil matters or other provisions basically
yes, sir,
because it's
that is an
offense.
offense. But
Uh,
since I'm doing it physically, it will not come under IT Act, right?
of course, yes, it will not come under the IT Act. But what
So
our
that is
question
what
is,
I have
it
chosen
is
for an answer.
no. It is, see, you have to look at an offense basically. Offense is offense, whether you do it physically or under the IT Act. That's what I'm meaning to tell you. What you're doing is a physical offense, but just because you're not doing, just because it doesn't come under the IT Act, you cannot call that as an non-offense. No, still it's an offense. It's a physical offense basically. It's not something which can be completely moved away from offense. You get the point of what I'm trying to say. Offense versus a contravention, whether you do it physically or not, the word offense doesn't change there. Basically, it's still an offense. Which of these is not an offense under the IT Act? That's what we are meaning to say. See,
Okay,
just
sir,
because
got it, got it.
because the fact is whether it's an offense or a contravention. Basically, no, this is a contravention because it's a simple violation. Basically, cheating by impersonation is a different one because if I have the intention, see what am I trying to do in impersonation? I am trying to take the identity of someone, pose as if I'm somebody. So there's an ill intention there automatically, and there's an act that I'm doing wrong. So both these are present. So under any law, it's an offense basically. So I am trying to say which is not an offense at all. So which means that B is the right answer. Because in this, you can never try to mean this as an offense. Because merely securing access is not an offense. If there's an intention done, yes. Otherwise, it's a problem. Are we clear on that?
Yes, sir.
Okay. 17th question. A steals a hard disk belonging to B. Which of these provisions of IT Act will apply? Obviously, it's going to be 66 because I have the understanding that it's not mine. So steals again using a stolen computer resource. 66B will come into picture automatically. If you look at section 66B, I told you that you will not be just charged for stealing the device, but also whatever data is residing in it, you will also be accused for that. 66B. Are we clear on this?
Yes, sir.
Okay. Let's go to the 18th question. A sends a pirated music file to B through WhatsApp. Which of these provisions will apply? So I have an intention that there is piracy here. So therefore, dishonest intention is there. Therefore, this is a computer-related offense. 43B because I download, copy, extract data. I downloaded. I must have downloaded that from somewhere. Otherwise, how will I get the pirated file? So therefore, 43B and 66 will come into picture. Are we clear on this?
Yes, sir.
Let's go to the 19th question. A alters a computer program, and as a result, the output becomes entirely different. So therefore, what happens in this? So computer program, when I manipulate a computer program, what happens there? It's a source code that I'm manipulating, basically. So 65 comes into picture automatically, knowingly and intentionally. Go back and see what we discussed. And 66, because I have pretty well the understanding that I'm altering the computer program, so there's a act that I'm doing wrong, and I pretty well know that the output also had become different. I am aware that if I change anything, if I alter it, therefore anything that I alter basically again has a dishonest and fraudulent intention. So therefore 66 comes into picture. 43J because again go back to the civil provision. So I can use civil and criminal both these provisions under this particular case because I'm altering it. I'm altering a computer program, which is again going to result in a different output altogether. So therefore, I am still going ahead and doing something which is offense with respect to computer source code, because computer source code definition has computer programs also in it under the ITI. So therefore, 43J, 65, and 66, all three will come into picture. So am I clear on this?
Yes, sir.
Okay, let's go to the last question. An employee of company located in Hyderabad sends an email from Bangalore to company C located in Delhi. An employee of C accesses the email from Varanasi. Identify the place of dispatch, place of receipt. So place of dispatch will be the place where the originator is located. Who's the originator? A is the originator. So the place of dispatch is Hyderabad. Place of receipt will be where he actually had his principal place of business. So principal place of business here is in Delhi. So if you look at it, company C, basically. So therefore, the place of receipt will be Delhi, because wherever the company has its office, so that will be considered the point. Are you clear on this? If an employee is located somewhere, we are not concerned about where the employee is located. Our only concern is where the company is having the principal place of business. So here, the company, the first, in case of originator, again, it's Hyderabad. In case of the other company, it's Delhi. So therefore, you're clear on how both these are, basically, right? Because company is located in Hyderabad. The first one is Hyderabad. So Hyderabad is the place of dispatch. And the other one, yes, we have the company located in Delhi, basically. So therefore, Delhi is the place where the company is located. So that's the place of receipt. So are we clear from here? Any doubts? Any clarifications?
No, sir, we are good with this one.
Okay. So more or less, I think we discussed all these questions. So I hope you got some understanding on the same, basically.
We hope so.
So let's, Vijay, can you please share the PPT in the meantime so that we get to the discussion right away?
Sure, so I'll be sharing it.
So today we are going through a very interesting proposition altogether, which is going to be really helpful in terms of your professional practice as well, which is totally talking about data protection legal regime under the IT Act. So we'll be going through what kind of legal regime we have with respect to data protection. We'll also be looking at who's an intermediary and what are the intermediary guidelines as far as law is concerned. We'll also be looking at some interesting points of cases. I'll also be sharing with you what is personal and sensitive information so that we are also getting that idea. And we did in the last session where we drafted out 65V certificate, we are also going to draft out a privacy policy and a disclosure policy under the IT Act so that you'll have an understanding how a privacy policy is prepared. And I'll also like to understand from you with respect to what how the other privacy policies of organizations are prepared. So you could also identify whether they're in compliance with the IT Act or not. So we'll also be doing that exercise of going through some popular privacy policies where we'll be trying to analyze how compliant they are. So I would want to hear your inputs with respect to the same. So without getting much delay, I just wanted to right away get into my presentation. Ma'am, who will be helping me to move my slides today?
So meanwhile, I'll be doing it because
Okay.
Vijay has. Is my screen visible?
Yeah, it's visible. Participants, is the screen visible?
Yes, sir, it is.
Yes, we are good.
Ma'am, can we go to the next? Yeah. So we fundamentally have to look at two parameters. One is sensitive personal data or information. A second is personal information. So sensitive, I'll put it in simple terms so you can understand. Sensitive information and personal information. So what do you mean by sensitive information? Whatever you are able to see on the screen over there. Passwords, financial information, biometric related information, sexual orientation, gender related information, health conditions and health records, and any other information required under a lawful contract. So I'll repeat it once more. Law has come up with something known as sensitive personal data or information. So what is the sensitive personal data or information? These are something which are called sensitive data or information. Number one, passwords, whether they are manually generated passwords or automatically generated passwords, any password. Financial information, your bank account details, credit card details, debit card details, ATM details, PIN numbers, etc. Whatever are relating to your financial information, your credit card statements, bank account statements, all these are financial information. Biometrics, specifically fingerprints and other things, fingerprint related information. Sexual orientation, your gender related information, whether you're a male or a female, all those kinds of information. Health records. Health records include, any of your prescriptions, the reports, and your documentation with respect to your health. For example, if you have a certificate, medical certificate is also a medical record. Health condition. Health condition means the respective condition that you have with respect to a person. For example, health condition. Diabetic. Diabetes is another health condition. Blood pressure, BP, is also health conditions. So this is how health records differ from health conditions. End of the day, health records may contain health condition, but health condition need not always contain health records. So therefore, what I just wish to tell you is any of these information, basically, that you're able to see on the screen, passwords, financial information, biometric related information, gender related information, health related information, is your sensitive personal data or information. We call this as SPDI. So S stands for sensitive, P stands for personal, D stands for data, I stands for information. So we call this in legal terms as SPDI, sensitive personal data or information. So these information are called sensitive information. So apart from this, we also have something known as personal information. So I'll also tell you what is personal information. So just wanted to tell you this is sensitive. This is what we mean by sensitive personal data or information. Are we clear on this? Any doubts, any clarifications that you wish to seek? If you're clear, please let me know so that I am also aware of it. I can move to the next slide. Passwords, financial information, biometric related information, sexual orientation, health records or health related information. So are we clear on all of these?
Yes, sir.
Done. Yes, ma'am. Let's go to the next slide. There is an exception. What is the exception? Any information that is available in public domain is not considered to be sensitive personal data. Any information which is available in public domain is not considered to be a personal data, sensitive information. Sorry. Second, any disclosure that you make under the RTI, Right to Information Act. So you might have seen a lot of companies also have in place the RTI disclosures. They even on websites you see RTI disclosures basically. So any such information which is disclosed or made available as part of RTI is not considered to be sensitive in nature. Second, any information which is available in the public domain is also not considered as sensitive information. So those are the two exceptions to it, basically. So please understand that this is the reason why I was just talking to you about WhatsApp. Because the problem is, when you look at the terms and conditions of WhatsApp, it very clearly states that whatever you share on WhatsApp, audio, video, image, or text, becomes information in public domain. And that is the reason why I told you that should you want to use WhatsApp for the purpose of sharing any information, please remember that you can no longer claim that as sensitive information under the law. So that is the reason we recommend not to share any kinds of sensitive information across WhatsApp. Because the reason being, once it becomes information in public domain, there's no longer the concept of sensitivity with respect to that information. So therefore, you can no longer exercise the rights, the obligations with respect to your sensitive data if in case that such data becomes available in the public domain. So please understand the fact that any information disclosed under the RTI and any information made available under the public domain is not considered to be sensitive in nature. So you know now what is sensitive information and you also know what is the exception to it. So are we clear on these two aspects? Any doubts, any clarifications?
So,
Participants,
sir,
are you clear?
suppose
Please
if
go
I
ahead.
share some information with you on WhatsApp,
Okay.
okay,
Okay.
does it become a,
Hmm.
a public information?
Definitely, under the terms and conditions of WhatsApp, it's public information in public domain. That's the
Okay.
only reason why we recommend not to share, bank account details, photographs, and other things on WhatsApp. Because the moment you do that, should anything be misused tomorrow, you can't take a legal remedy because it's already covered under the exception, for which again you cannot basically, use any kinds of legal provisions for filing a case on privacy and other things. So uh, that is the only reason we should look at the terms and conditions very, very carefully so that you should understand whether the set terms and conditions regard any disclosures made through such applications as personal information or they will consider that as public information. So that is the reason why we encourage you to read the terms and conditions of applications before you actually make use of the same or before you actually try to use them for sharing any information. So I hope you got the understanding of the same. Are you
And it
clear
is
on it?
same for the recipient and for WhatsApp both.
Anybody, see, because for WhatsApp, see, ultimately when you use WhatsApp, you are agreeing to the terms and conditions, and then only you are making use of WhatsApp. So electronically, you just understand you are given acceptance to the terms and conditions. So it's almost like you accepted the terms legally speaking. This is a e-contract. Because what is an e-contract? There's a document that it's almost like physically signing an agreement and then going ahead and doing it. So just like how you're doing that physically, you're actually trying to do that electronically by just pressing I agree, I accept. So this is the legal significance that you'll have to keep in mind. So that's why we say, please be aware on before you click, uh, think before you click, because otherwise what happens is, with or without your knowledge, you automatically give consent to the same. Once you give consent is equal to actually physically signing a document, so you're accepting the terms and conditions. So that is the reason all these companies are trying to make use of this particular advantage, and they're trying to put in left, right, and center all kinds of terminologies, because they pretty well know that this is going to be legally acceptable. Second, they pretty well know that no user is going to scan through them in a detailed manner. So that is the advantage that these people are actually trying to make use of for the purpose of their own activities.
Got it. Thank
So are
you.
you clear on that, basically?
Yes. Yes. Yes.
So not only this, even Facebook for that matter. And more so, please understand one more very important factor. The, the important aspect that you'll have to keep in mind is what happens in case of sharing of data. That's another aspect. So please be aware, when WhatsApp and Facebook both were run by the same company, basically, please understand what could be the legal aspects that you should look into in those areas. What happens to my data? What happens to the terms and conditions of the data thereof? So you'll have to be very well aware about how this has been put in the terms and conditions. What does the terms and condition state with respect to data sharing? They might just say one thing, that should we have any business partners, should we have any affiliates, we'll share your information. But please understand how the information is shared, what is the purpose of sharing that information. That will be very, very important, so that you can take the right call with respect to sharing the right information. So that is another piece of advice that I just wanted to tell you. So are you clear on these two areas? Any doubts, any clarifications? We
Yes.
now
Clear. Thank
discussed about sensitive information and exception to it, because this is very, very important, participants. And I would really like to understand your feedback, because see, if you randomly look at an average, 99% of the websites of mobile applications are not compliant with these. So it's a very, very big learning that you should keep in mind, because should your organization be doing this kind of activities, you must ensure that you actually try to bring these on your policy requirements, because this is going to be really something that will add value to your policy and will make your policy legally compliant with the IT Act and the rules and regulations made thereafter. So merely policy versus a legally enforceable policy, there's a lot of difference between both. What was as what we discussed. Please go ahead. Are we clear on this?
Yes, Sushant, I have a question.
Please go ahead.
So,
Go ahead. Go ahead.
if a business decides to use WhatsApp for a business transaction or purpose, and
Correct.
so how is that the data information shared in WhatsApp is not classified as public? Because that is meant for business purpose, like say example diagnostic center, and
Correct. Absolutely.
they provide health reports to customers through WhatsApp. You know,
Correct. Should
and yeah.
actually factually they shouldn't be doing that.
Mm.
See, factually they should not be doing that, because the reason they do that, they're exposing not just their information but their customers' information to what on WhatsApp.
Yeah.
So this is a very critical aspect. So therefore, you'll have to keep that in mind. Basically, that is why we keep advising. Now we're working with a healthcare company who's actually into all of these diagnostics related areas. But we the first thing that we told them is, be different in your approach. I understand that you are wanting to make the user experience very friendly. That's absolutely agreeable. But it should not be at the cost of risking their privacy element on public domain. That's what we are looking at. So that's the reason we also advise people, do not share your health reports or anything on WhatsApp. So that's highly discouraged, if you ask me, from a legal perspective, because otherwise I can actually sue you for doing that, because unless you understand the terms and conditions of WhatsApp, you can't use it. So that is why we say companies, please look at the terms and conditions, be very careful on it. Because the challenge is the moment I'm trying to, put in my terms and conditions here, and moment I'm downloading it, a company cannot take, a defense that I did not know what the terms and conditions are. Because unless and until I understand, I'll not be able to download it. So it is legally presumed that when you download it, you have read through the documents completely. So that is why the corporate liability on the company will be very, very huge, because you cannot take the defense that I never knew what I was actually looking at. So are you now aware of the importance of this?
Yes.
Because do any integration, see, take that matter take that matter. If you integrate your WhatsApp onto any software or any domain, for at least, let's say, for giving you some feedback on the orders or on these reports or anything, unless and until you downloaded you have an API or something on your platform, you will not be able to actually deliver. 1 second, 1 second. So until and unless you download, the application, you will not be able to use it. And when you're downloading that, you should have you automatically have the terms and conditions specified there. So it's very important that you go through that and then only accept it. Otherwise, you cannot say, I never knew what the terms and conditions were. So that's the big challenge that we have from a legal perspective. So this is what happens with companies when they actually sign up or have these updates configured on their platforms, either for employees or for their clients or customers. Because even a company, what you have to remember is, even a company has to emphasize that they have to have due diligence even for employees' data. So should your data as an employee be collected by a company for employment purposes? There's no exception. Still, if since they obviously have these details with you, no, obviously for making your payroll, transferring payment to you through your payroll system, they will be collecting your information which is financial in nature. That means the account numbers and things like that. Second, they would also be required to have in place information with regard to your health, because should you wish to take any leave, for example, let's say sick leave or a medical leave, you will be producing a medical certificate. Likewise, when you want to go ahead and seek some kind of special leaves, especially if you're wanting to take paternity leave or maternity leave, obviously gender related information is available again, basically. So that is another aspect altogether. So therefore, companies should be also aware of these particular aspects totally. So are you getting what I'm trying to put in? Are you aware of this?
Yes.
No.
Yes.
So this is why we call this as a primary agenda altogether. So let's go a bit more further. Ma'am, can we please move to the next slide? Now let's understand what is personal information. So any information with which I can identify a person. Any information using which I can identify a person. Person means a natural person. Who's a natural person? A human being. So participants, please understand that this is very specific to individuals and not specific to companies. So please get the point right. Any personal data of companies is not regarded under IT Act, because it's not relating to natural persons. So therefore, natural persons versus legal person, there's an entirely big difference that you have to keep in mind. Company is called a legal person. A normal person, a human being, is called a natural person. So please understand the distinction between a natural person and a legal person. And the IT Act specifically talks about the protection of the personal information or sensitive information of individuals. It does not talk about the protection of this information with respect to company, because when you interpret this, companies have different legal existence altogether. They are not natural persons. So therefore, you cannot have biometrics of the company. Company has to be existing when it cannot exist without individuals. So if I were to say this is the payroll of the company, then the company's financial statements will not be considered as sensitive personal information. The personal information of individuals, for example, bank statements of an individual, can be considered as sensitive information. So please understand that personal information and sensitive information, usually they are attributable only to personal human beings, basically. So please understand the fact. So For sensitive means what we discussed: passwords, biometric information, sexual orientation, health-related information, and others. Personal means any information which is capable of getting, which is capable of identifying a person altogether. So this is personal information. So now do you understand the difference between sensitive and personal?
So, question here,
Please,
Sushant.
please, please go ahead. Go ahead.
Yeah, here it is mentioned natural person. Cyborg comes under natural person or
Who?
human cyborg.
Cyber,
Human.
we're not concerned about cyber here. There's no cyber
No, no, no.
involvement here at all.
Okay, sorry. Maybe my bad pronunciation. Cyborg is a human implanted with chip in the brain. So
Okay.
it's a cybernetics and human together.
Okay.
So
Okay. That's an interesting proposition. It's a see, we may not be able to apply that to a natural person. To cyber. Please pronounce it once again.
yeah, it's
Cyber.
CYBORG. If I'm right.
Cyborg. Okay.
Yeah.
Okay. Okay. So could you just once again repeat what you're trying to tell me?
Yeah. If a person is like that, and then can he be considered as a natural person?
Is he a
So
natural person? Is he a human being? Human being implanted with something, you're trying to say?
Implanted with cybernetics in the brain. So
Okay.
control.
Okay. See, how is he? Other than that, he's a natural person only. Basically, it's a very good point that you have brought into discussion. Actually, legally speaking, I can actually try to consider him as a natural person itself because he's naturally living, just like you and me.
Yeah.
But technically speaking, there is a provision because there is a chip, etc., inserted in his brain.
Yep. Yep.
But physical existence of the person is still there. No, I can identify. He has an Aadhaar card. He will be having a driving license. He will be having other things.
Yes.
So therefore, as long as you have that, you can consider them as a natural person himself. But it's a very interesting proposition. Thanks, for the same that you got this into discussion. It's an unexplored territory, actually, uncharted
Yeah.
territory.
It is something. It's evolving area actually. It is
Correct,
the
correct,
future.
correct. Correct. And it's a very interesting provision. Thank you so much. I made note of it. We'll also look at that as a research perspective. But legally speaking, I can still call him a natural person because the natural person still exists. No, if there is a natural existence of that person, still I can call him as a natural person itself. So, do you now get the difference between sensitive and personal information both? And exception also we discussed. Any information under RTI or any information which is available in public domain, that is accepted. There's an exemption given to it. So, are we clear on these two areas? Participants, are we clear on this? Let's go to the next slide, ma'am. Yes. Now, let us go through a very important concept known as an intermediary, and then we'll break for we'll take a break for 15 minutes and then come back again. So, I just want to talk to you about intermediary. Just give the background and leave it, and then we'll discuss further on it. So, intermediaries are under the IT Act are very simple. I am not getting into the definitions, etc. of the other things which you are able to see on the screen. I'll just tell you one fundamental area. The moment any person, either directly or on behalf of somebody, is receiving, storing, transmitting any electronic record or providing any service with respect to that electronic record. I'll make it much more simpler. You know what an electronic record is. So you're clear on what is an electronic record. Suppose, let's say I'm an individual, correct? I'm collecting information from you in the electronic format. That is also an electronic record. So a simple activity. I collect data from you. I provide service with respect to you. That that becomes an intermediary altogether. So let's take Reva for that matter. Reva is also a intermediary. Why? It is collecting all our information, and obviously all our information is collected in email. Most of it, at least my information is collected through email. So therefore, it is providing service. What is that service? It is providing education as a service. So thereby enabling these lectures and things like that. So it's an intermediary. So thereby you understand anybody. It may be a body corporate, it may be an sole proprietor, it may be an association, it may be a professional like me or a doctor or a chartered accountant or anybody. Basically, if I collect any information electronically and I provide services, therefore I become a intermediary. So it need not be only intermediary, does not only mean a service provider like an internet service provider or a telecom service provider. Anybody basically who's collecting and storing or providing any service online becomes an intermediary. A simple website of a company is also an intermediary. Why? What is it doing here? It is collecting definitely my information. So what is the information? You may say, I have a simple website, let's say abc.com. It's a simple website showing to the people that these are my services. I don't have any other data that I collect. It still is an intermediary. You know why? What happens when you access a website? Technically, when you access a website, automatically your IP address gets recorded in the server, which means your IP address is also your personal information. Why is it personal information? Because I can identify you based on your IP address. So therefore, that is the broad understanding with which you have to look at the intermediary. So even if I'm running a small ordinary company website just to showcase about my services, I'm still an intermediary, because what is it that I'm doing as an intermediary here? I'm collecting your information electronically because my IP address is collected electronically, and I'm providing a service to you. You may say, what is the service? I'm not. You're not taking my services. How can I say? How can I call this as a service? Basically, I'm providing information as a service to you, which means that through my website, I'm trying to provide information to you, saying that these are the services that I offer. So that means information is provided here as a service. So please understand that a mere company website is also a intermediary under the IT Act. So that's the whole agenda that I'm trying to focus on. Are we clear on that? So intermediary means any person, either directly or on behalf of somebody, either if he receives, stores, or transmits any particular electronic record, or provides any service with respect to that electronic record, becomes an intermediary. So please understand that point there. It could be an individual, it could be a company which is a sole proprietor company, a normal private limited company, a public company, a body corporate, maybe an association, just like you have the alumni association, all these kinds of associations. It may also be, the what do you say, one person company. It could also be even individuals who are professionals. For example, lawyers who are individuals. I run my consulting firm, but had I been a normal practicing lawyer, I'm also an intermediary because I'm a professional. So therefore, any professional, which means a doctor, chartered accountant, a lawyer, anybody, all these people who basically collect information electronically and provide any service with respect to that information, those people become an intermediary. So therefore, just understand the broadness with which the term intermediary has been defined. Because in the other countries, they have sector specific compliances. For example, say if you look at the US has specific compliances. For example, if you're collecting healthcare data, you should comply to a compliance, which is known as the HIPAA compliance. Should you collect any other financial data, you should comply with PCI DSS. So there are standards laid down for specific kinds of information. But the IT Act is very clear in saying that, hey, if you collect any information electronically, and if you provide a service with respect to that information, you become an intermediary. No matter whether you're an individual, you're a company, you're an association, you're an enforcement agency, you are a government, you're a governmental organization, I don't care. So I do not have any concern for that. My concern is so long as you're collecting any information electronically or providing a service with respect to that information, you become an intermediary. So even a government department, the ministry of the government is also an intermediary. And lo and behold, the law has not carved out an exception for any kinds of governmental organizations or organizations dealing with government or quasi-government, or for that matter, let's say, even the ministries. There's no exception given there and so that is the uh, broadness which with the term intermediary has been defined. That's something that I just wanted to share with you. So I hope you got an understanding of the same. So let's discuss more on the intermediaries after the break. You can break for break now. It's 11:35 now, probably 11:55. You can come back and then we'll start our discussion on the intermediaries as well. Participants, are you back from the break? Participants, are you back?
Yes, sir, we are ready. Yeah.
Great, great, great. Ma'am, can you please connect the PPT?
Sure, sir.
So we were just talking about intermediaries. So, I was just trying to tell you, the broadness with which the term intermediary has been defined. So therefore, I hope you got an understanding of intermediary. Are we clear on who's an intermediary? Any doubts? Any clarifications? Participants, are we clear? Any doubts? And who's an intermediary?
Yes.
Because I believe that understanding about who's an intermediary plays a very, very, very vital role in terms of this entire data protection legal regime. Because should you not get a clarity on this, it will be difficult to understand and look at the intermediary guidelines also. So I believe let's get the point right of who's an intermediary, because these intermediaries are going to be people whom I think are far more in a higher position than the government also, because they have so much of sensitive and personal data that is made available to them that I don't think even the governments and the ministries have so much of data or information today. So they're far more powerful today. And the first thing that you and I have to look at is when you have these respective matters in place, identification of the intermediaries would be playing a vital role. So that's the reason I was just wanting to clarify whether you have a clear understanding of who's an intermediary or not. Ma'am, can we go a bit more further to the next slide? Yeah. So intermediaries no longer just include telecom service providers or the internet service providers, but the law has come up with some distinctive uh, people who could be termed as intermediaries. Telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online marketplaces, online auction portals, online payment sites, and cyber cafes. So basically, if you look at it, I just wanted to tell you one more thing. Should you or your company offer Wi-Fi to your respective employees or to your respective members, you would also now be looked at as a network service provider. So apart from just intermediary, should your company, should your organization provide Wi-Fi connectivities to their employees, they would also be now looked at a network service provider perspective. So therefore, it's very, very important that today we understand about network service providers as well. So should there be any company offering Wi-Fi in its respective premises? Or we look at a lot of places, no, the common places. You go to a shopping mall, you go to a restaurant, you go to a cafe, you go to any place, a movie theater. I think almost all places today give you an option of connecting to Wi-Fi. Even a hospital for that matter, they give you free Wi-Fi. So the moment they're giving you this Wi-Fi connectivity, they're actually recognized as a network service provider under the IT Act. So therefore, they'll have to keep in mind that their only way to look at the fact that they comply to IT Act is have in place due diligence and reasonable security practices and procedures. So therefore, we have a very good news and a bad news too. So let me tell you what the good news is. The good news is the law is very clearly stating that should you, as an intermediary, exercise due diligence and have in place reasonable security practices and procedures, the law is going to now give you statutory exemption to liability. So what does it mean to you? It means that if you're an intermediary, if you comply with the law and still in the event should you have any kinds of issues, whatever be the issues, should you be attacked, should you have any kinds of a data breach, or should there be any kinds of issues on your company, you do not have to pay any amount of liability by way of damages, or you don't need to face any criminal charges at all. So that's completely waived off under the statutory exemption given by the IT Act under section 79 specifically of the IT Act. So 79 is a safe harbor provision which is provided to intermediaries in case they exercise due diligence and they have in place reasonable security practices and procedures. So that's the good news. What's the bad news? The bad news is, should you as an intermediary do not comply with the IT Act, the rules and regulations made thereunder, should you not have in place reasonable security practices and procedures, or should you not exercise due diligence under the IT Act, you are in for two kinds of liability. What are those two kinds of liability? One is civil liability, the other is criminal liability. Civil liability could be damages by way of compensation up to 5 crore rupees per contravention. So we discussed about section 43, which talks about the different kinds of civil matters, where I told you that any person without the permission of the owner or the person in charge of the computer, should they do any of the aforesaid activities, access, secure access, download, copy, extract data, introduce a computer contaminant, damage the computer, uh, deny the access, uh, use the charges availed by one person on the account of other, facilitate access to any other person, diminish the value and utility of a document, and affect it injuriously, uh, delete, conceal, and alter the source code, or do any of these aforesaid, you could actually face damages by way of compensation up to 5 crore rupees. So that's the kind of damages that the intermediaries could face. Second, you could also face criminal liability, and that criminal liability could be by way of imprisonment ranging from 3 years to life imprisonment, and a fine ranging from 1 lakh rupees to 10 lakh rupees. So these are the different exposures that you as an intermediary could actually be facing in case you do not comply or have in place reasonable security practices and procedures. So that's the broad bad news that I have in for you. So good news, you comply and you have the safe harbor provision. The bad news, you don't comply, you get exposed to two kinds of liabilities, civil and criminal wise per se. So we'll just discuss about the penalties and the punishments so that you also have an understanding of the same. But this is just to give you a broad perspective on the intermediaries and their legal liabilities per se. So are we clear on this? Any doubts, any clarifications? Please let me know. If you're clear, please give me a response so that I can go further. Participants, are we clear till here?
Yes.
Great. Ma'am, can we move to the next slide? Now, the first thing that you will have to keep in mind as an intermediary is you will have to look at this takedown notice. What do you mean by this takedown notice? If there's anybody who's getting affected either by way of your content or images or any other forms of issues. Let's say that somebody says, hey, I'm affected or I face issues because of your content specifically being put up on your application, either your website or your mobile application or your software or your platforms. Then what is the takedown period? The takedown period is 36 hours. The takedown period is 36 hours. And how does this 36 hours get calculated? So let's say that I am affected with a website, let's say abc.com. So let's say that the content being displayed on abc.com is affecting me. So therefore, what I try to do, I try to raise a grievance. I try to raise a grievance and I submit my grievance to the grievance officer, and I tell the grievance officer that, look, this is the content on your website which is affecting me, and I drop an email. And the takedown period starts from the time when the mail reaches the inbox of the respective grievance officer. So from that day onwards, from that time onwards, the 36 hours starts ticking. So therefore, you will have to be cognizant to the fact that 36 hours from the time you receive an email with respect to the grievance. So that is the takedown notice as an intermediary. So should there be anybody who's raising any kinds of issue with respect to the content being displayed on your website or on your computer resource, the takedown notice is 36 hours from the time they actually submit that grievance to you. So therefore, that's the first parameter that you'll have to keep in mind as part of your due diligence. So are you clear on that 36 hours time takedown now period? It starts from the time the grievance is received on through by the grievance officer through an email. Now, before even getting into that, I would just like to tell you that every intermediary is actually now required to appoint a grievance officer. So, who's a grievance officer? Anybody who could actually address grievances with respect to sensitive personal data being stored, received, or handled by your organization. That person should be appointed as a grievance officer. So, in a nutshell, your customer support could be actually somebody who could potentially be acting as your grievance officer. So, you should first make an appointment of that. Second, you're supposed to make the details of the grievance officer made available on your platforms. So, if you have a website, if you have a mobile application, and if you have any kinds of platforms or a product, you should ensure that the details of the grievance officer are specified there. What are those details? Number one, the name. Number two, the email ID. Number three, the respective format for raising out grievances. So we have a standard form where should you get affected in any manner by any of the content being displayed on my website, my mobile application, or for that matter, my resource, then you are supposed to report that to me via submitting the grievance, and that grievance should be submitted to the grievance officer specifically via email, and the details of the grievance officer's email should be specified there. And not just that, I must also display the format, in what way that particular content is getting affected to me, and I must also signify my name, my other details, wherein I'm trying to establish the fact that I'm getting affected and I'm the affected party. So proving that I'm the affected party becomes a vital situation, because failing which we would not be able to distinguish between a genuine compliance, genuine, what shall I say, grievance request and a fake grievance request. Because given the time that we are in today, it's very easy for anybody to actually point out and raise a fake or a false alarm. How do you distinguish which is a false alarm and which is a genuine one? The only thing that you will have to look at it is put the onus of responsibility on the person raising the grievance. So, should they be the affected party, they must be explaining how this particular content on your website, on your mobile application, or on your platform, on your computer resource is affecting them. And they should also signify what kind of an impact is it having upon them, and what kind of an effect do they have upon the as an affected party. So should they specify all of these, we will look into that. Should they not specify that, we would not be looking into those grievances basically. So if you are able to lay down the process grievances, I think that could be one way to stop the menace of fake or false alarms. I don't say this is a foolproof mechanism, but I would say this is a reasonably secured mechanism. So I hope you got an understanding upon the same. So the first thing that you will have to do as an intermediary now is to have a takedown notice of 36 hours. So make your grievance officer aware that 36 hours is the timeline that he has to now keep in mind for actually uh, taking down that particular content from public display. So now you would say, what is that a grievance officer will have to do as part of the takedown period? Okay. Now, should a grievance be submitted within 36 hours, first you'll have to disable the said page or content to the public access. The first thing that you will have to exercise as part of your due diligence is, once you receive that, within 36 hours, you will have to first disable the access to that affected content or material initially. And then you can start doing your internal investigation. Should you find out that there is a genuinity in the claim, you can go ahead and act upon the same. Should you think it's a fake claim, you can drop an email and close the matter. But what becomes really essential is blocking that information within that takedown period. of 36 hours, failing which you could be exposed to legal liabilities. I also have a very interesting case to talk to you about in this regard, but just to tell you that that's the first and foremost criteria that you will have to exercise as an intermediary. So are you clear on this area? Any doubts, any clarifications? Please let me know. Are you clear on this?
Yes, sir.
Great. Ma'am, can we move to the next slide? Yeah. So this is the second thing. As an intermediary, you should ensure that these policies are actually published on your particular computer resources. So you must have in place a privacy policy. You must have in place a user agreement. So these are the primary two things that you'll have to be aware of, apart from the grievance mechanism. So grievance mechanism will be the first document that you'll have to comply with. Second important aspect is you must have in place a privacy policy and you must also have in place a user agreement. And both the user agreement should be in specific with respect to the sensitive and personal data being collected. So this is under the rule number 3 of the IT rules 2011. So what does it say? It says that should you be an intermediary, what is the other way to exercise due diligence? This is another way to exercise your due diligence. So many due diligence parameters have been given. The first thing that I talk to you about is the 36 hours takedown period. So have a policy in place. Second, you can have a grievance mechanism in place where grievance officers' details could be mentioned and the format of raising a grievance could be mentioned. Third, one of the other parameters that the law has for you as an intermediary is you should have in place a privacy policy. And apart from just having a privacy policy, you also required to have in place a user agreement. So this user agreement should be very specific to the sensitive and personal data collected, processed, and handled or transmitted by you. So this is the legal requirement. So this is the third part of the legal compliances that you have as an intermediary. Yes, ma'am, can we go to the next slide? Now, this is the provision which talks about the civil penalty. So, therefore, look at this. It very clearly says that compensation for failure to protect data. So, when can this be exercised? If you're a body corporate, that's what I was trying to tell you. And who's a body corporate? Any company, any association of individuals, any sole proprietor, any individual rendering professional services is covered under this particular provision. So if you are a body corporate, if you're possessing, dealing, handling any sensitive personal data or information or personal information in any computer resource that you own, you control, or you operate, should you be negligent in implementing reasonable security practices and procedure such that failure has resulted in a wrongful loss or a wrongful gain, you would be liable to pay damages by way of compensation to the affected person. So it's very simple. Should you not exercise due diligence, should you not have in place reasonable security practices and procedures, as a result, somebody is getting wrongful loss or wrongful gain, then you would be required to pay damages by way of compensation to that particular affected party. So that's the broad message that this section has. So failure to implement reasonable security practices and procedures and due diligence under the IT Act would result in these kinds of liabilities, which are civil in nature, specifically under Section 43A of the IT Act. Now, this, in case you intend to seek criminal remedy, what do? You have Section 72A of the IT Act, which is a criminal relating provision relating to the same. So we'll discuss about that as well. So are you clear on this 43A? If you do not have in place a reasonable security, or should you be negligent in implementing reasonable security practices or due diligence, you could be in for damages by way of compensation. Are you clear on this?
Yeah, and how will we define what is a reasonable security practice here?
That is what I'm exactly trying to tell you. reasonable security practices and procedures have been defined under the law, specifically under Rule 8. So we'll discuss about what is that as well. So whatever are specified under Rule 8, we have some parameters being specified. For example, operational, technical, managerial, financial, organizational. So you should have your normal measures in place. For example, how do you talk about the physical control measures, access control measures? You can have proper access control being put, physical access control. Technically, you can have your firewalls in place. You can have the IDS, IPS, intrusion detection system, intrusion prevention system, and things like that. You can have some password protections. You can have these kinds of measures. Organization, as an organization, how do you restrict access to them? You can do that only on a need to know basis. That could be forming part of your organizational measures. Managerial, how do you manage the sensitive and personal information in your organization? Is there a respective access control or a flow that you have in place? Then what are those things? So all these are considered to be in the reasonable security practices and procedures under Rule 8. Apart from that, you would also be required to have due diligence. And how do you exercise due diligence? Have these three policies in place. Number one, privacy policy. Number two, grievance mechanism. Number three, user agreement. So should you have these along with your regular parameters, that itself is demonstrated evidence that you have in place the reasonable security practices and procedures. Are you clear on this?
Yes, thank you.
Thank you. Yes, ma'am, can we push to the next slide? Yeah. So this is what I was trying to talk about. Body corporate also means a company, an individual who's engaged in professional or commercial activities, a firm, a sole proprietorship. So even a partnership firm is considered to be a body corporate under this particular definition. So in simple sense, anybody who's collecting and handling sensitive personal data or information or providing a service with respect to that record becomes an intermediary. Likewise, anybody who's basically collecting sensitive personal data or personal information electronically, he becomes, whether you're a firm or an individual, you are classified as a body corporate. So it may be an individual who's trying to provide professional or commercial services like a lawyer, a chartered accountant, and doctor. Or if you're a firm, okay, no problem, you're also covered here. Should you be a department of the government? Yes, you're also covered here. Should there be any organization of which is relating to the governmental organization? You're also body corporate. Should you be a normal private limited company? You're also a body corporate. Should you be a public listed company? You're also a body corporate. So this is the broadness with which the law has now defined the term body corporate. So therefore, broadly speaking, all of these people are now intermediaries as well as body corporates. So once you are a body corporate and once you are an intermediary, you should have in place reasonable security practices and procedures. Number two, have in place the due diligence. And I also discussed with you some due diligence parameters. We'll also discuss the other due diligence parameters as well. But just to give you a broad glimpse, this is the outlying factor that you will have to keep in mind. Yes, ma'am, let's go to the next slide. Now, I looked at a criminal perspective here as well. I told you you could be exposed to two kinds of liabilities. One is civil, 43 capital A. Now, 72A is the criminal offense. What does it say? It says that punishment for disclosure of information in breach of a lawful contract. So, what is that? It means if a person, including an intermediary, while providing services under a lawful contract, so therefore you have a lawful contract. What do you mean by a contract? Let's say that you and I enter into a contract for services, and you since I am a lawyer, you wish to engage me for your legal matters. So I'm providing professional legal services to you. Should that be a situation here? If I get access to your sensitive personal data as part of the professional engagement, which is a lawful contract again, and I disclose that information knowingly and intentionally to somebody else, then what happens in that case? I could be facing criminal liability. Criminal liability is with respect to Section 72 capital A under the IT Act. Civil liability is 43 capital A. Criminal liability is 72 capital A. So 43A, 72A. So that's the civil provision, this is the criminal provision. and imprisonment up to 3 years, 5 lakh rupees fine, or both. It's the discretion of the respective court. So all I wish to tell you is, yes, in addition to this, we also have certain other sections where we'll be talking about, but just to give you a broad glimpse, I was just trying to give you this understanding. 43A read along with 72A. I'm clear on these two areas? Now we got the understanding? 43A, yes. And 72A, yes. I clear on these two areas? Participants waiting for your feedback.
Yes, sir, we are good.
Great, excellent. So now you understood the criminal provision, civil provision. Please go ahead.
Sorry, how to choose which section apply for a service
Very good
provider?
question here. Very good question here. So what is it that you're looking at? That's really the important factor that you have to look at. Do you want to get compensation? Then you should use 43A. Should you want to exercise criminal remedy and send the respective service provider to jail for his incapacity for non-compliance? Then you can use 72A. We also have a very interesting section called offense by companies. I'll also look into that area as well. So it's your call ultimately how you wish to exercise your remedies available. You can exercise civil remedy. You can, should you want to get compensation. Should you want to send the organization's representatives to jail, you can use the criminal penal provisions. Should you want to do both, you are at liberty to do both. So that's the choice that you can make as an individual or as an affected party. The choice is yours. Either money or sending someone to jail, or if you want to exercise both, the law gives you both the options. So it's almost like KBC where you have the 4 options. You have civil, criminal, civil and criminal, all of the above. So therefore, you can choose all of the above. So you're in the hot seat to choose what you want. Yes, ma'am. Can we go to the next slide? Yeah, I have 3 very interesting cases to talk to you about, but before getting to that, I just want to get to the corporate provision as well. Ma'am, can we go to the next slide? The next. 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 I don't know whether I have put this slide. 1 second. Next, ma'am. No, next. Next. Yeah, so this is one provision that you can use in addition to 43A. Should you wish to get compensation? This section is section 45. So what does it say? It says very clearly that should anybody look at this question, it's very interesting. It's called residuary penalty. It's called residuary penalty. What do you mean by residuary penalty? Should anybody contravene the provisions and the rules and regulations of the IT Act, and you do not have a separate penalty being specified under for the same, but you think a Right Act has been violated. So what do you do here? You can get compensation up to 25,000 rupees under this section. So there's no harm in adding this section also for your compensation claim. Apart from 43 capital A, you can also use section number 45, where you exercise the remedy being given to you for a residuary penalty, that is liability for non-compliance, which is specific to an amount not exceeding 25,000 rupees. So this is additional section that you can cap on your respective case. Apart from just taking 43A, 45 could also be invoked. Ma'am, can we go to the next slide? Yeah, so this is a beautiful slide. The reason is this is offense by companies. Now, in case you want to send the company, you want to initiate a criminal action upon the company, who is going to be held legally responsible? Number one, the company being itself a legal person, so therefore it's going to be accountable and liable. Second, the top management, like the directors, the CEOs, the CXOs, and all those category of employees. And third, the middle management. And fourth, most importantly, each and each and every individual who is responsible for such data. Suppose you have a department which takes care of all the data. So should there be any breach or should there be any negligence in implementing reasonable security practices and procedures, you can no longer get away by saying it's the company's responsibilities, it's the CEOs and CXOs who will have to be paying attention to it. I'm just an employee and I'll just do my work and I'll just go away. That cannot be the legal approach that you can look at. The law is very clear in saying that the liability could be cast not just upon the company, but upon each and every stakeholder involved in this domain. So, which means the top management, the middle management, and each and every employee responsible for protecting or having in place reasonable security practices and procedures for their respective organizations. So, in short, if you're an employee in your team getting exposed to sensitive personal information of your clients, if your employees, you should also have in place reasonable security practices and procedures. Should you not do that, you also could face legal liability, and you could also be accompanying your top management to jail in your capacity of failure to exercise reasonable security practices and procedures. So this is the very important aspect that I would like to push here. The reason being, it's a corporate provision. All that you have to keep in mind is it's no longer just the top management, all the company. It's the responsibility of each and every stakeholder, including an employee, to have in place reasonable security practices and procedures. So please understand that should your company not exercise reasonable security practices and procedures while implementing or while discharging their obligations, be very careful, because should you be involved there and you do not have reasonable security practices and procedures, God bless you. The reason is you could face legal liabilities thereof. So therefore, that's the broad ambit of this section. So please be aware of this section, because apart from just the company's liability, you will also have to be required to have in place the reasonable security practices and procedures. So educate your senior management, your middle management about the same. Should your organization not have the reasonable security practices and procedures already, and apart from it, also due diligence, because that could be having different kinds of legal repercussions upon you as an employee as well, given this particular provision. And when are these companies going to be liable? They're going to be liable if it's proved that they had knowledge that such and such an offense or a contravention had taken place. So this is where I said WhatsApp. Should you integrate WhatsApp onto your software or a platform or any other tool, you are not having knowledge of the contravention. Why? The broad message is, when you look at integrating any kinds of third-party tools or API, please be alive to the fact that you'll have to go through the terms and conditions of that respective application. You can't just take the defense that the third parties would be liable, I will not be held liable. The third parties, yes, in practice would be liable for any actions arising due to the issues attributable to them. But at the same time, as an organization, as an intermediary, what is the due diligence that you will have taken would be playing a vital role in determining the landscape of legal liability. So the broad message is very clear that uh, if you had the knowledge of the contravention or breach, you would still be liable. Second, if you have not exercised due diligence, you can still be held liable. Third, if it can be demonstrated that it happened due to your negligence in implementing reasonable security practices and procedures, as also due diligence under the IT Act, you would be accountable for liability. So that's the whole spectrum of liability, shall I say, in terms of non-compliance. So two kinds of liabilities: civil and criminal. So in a broad nutshell, just before we break for lunch, just want to tell you the entire concept in just 2 minutes. Number one, if you're an intermediary, who's an intermediary? Any entity or a person, either directly or on behalf of somebody, either receives, stores, transmits any electronic record, or provides any service with respect to that electronic record, becomes an intermediary. So therefore, once you are an intermediary, you should have in place reasonable security practices and procedures and have in place the due diligence parameters. Should you do that, of liability at all, thanks to Section 79 of the ITI, which gives you statutory exemption. Second, should you or your organization as an intermediary not have in place reasonable security practices and procedures or due diligence, you could get exposed to two kinds of liabilities. Civil liability, damages by way of compensation; criminal liability, which could be by way of imprisonment ranging from 3 years to life imprisonment, and fine ranging from 1 lakh rupees to 10 lakh rupees. So these are the different exposures that you as an intermediary would be liable in case of non-compliance. And offense by companies, like I said, it's not just going to be the company per se, but the top management. Grievance officer, share those details.
Is it me or Sushant is not audible?
Yeah.
Voice is breaking.
Hello, Sushant.
Now
you
is it audible?
Yeah, yeah.
Yeah. So all I was trying to tell you is that the first due diligence parameter is 36 hours. That's I was just wanting to talk mechanism where you display the name and contact details of a grievance officer of raising a grievance. That's the second due diligence parameter. Third due diligence parameter is have in place privacy policy. Fourth due diligence parameter is have in place the user agreement. So these are the different due diligence parameters that the law has in place for intermediaries. So these are some of them. We have not discussed everything, but these are some of them that I was just discussing with you in the morning. So are you clear till here? Any doubts, any clarifications?
No, sir.
It's clear for you. And we also discussed what is sensitive and personal data. Personal data is any personal information, is any information with which you can identify an individual, including his employee ID, Aadhaar card, PAN card, bank account number, credit card number, then Aadhaar number, and then passport number, anything, IP address. Then sensitive personal data or information means passwords, financial information, biometric related information, sexual orientation, health and medical records and conditions, or any information disclosed under a lawful contract. So therefore, we discussed about these sensitive and personal data as well. And failure to do that, failure to have in place reasonable security can expose you to damages by way of compensation under section 43 capital A, read along with 45 you can look at for residuary penalty, should you want to take compensation. Should you wish to exercise criminal remedies, you can always exercise section 72 capital A and also 85 of the IT Act. Are we clear on these two elements? This is the broad sum up of whatever we discussed so far. So therefore, with this background, I think would have got a clue about the kind of intermediary liabilities and that's the whole parameter. I think I lost my connect. So are you clear till here? Participants, am I audible now?
Sir, your voice is not clear, sir.